The first real video of this fascinating series on employment law. So the fundamental basis of most employment law claims, most jurisdictions in Canada, is the common law. That's what generally is referred to as judge-made law. And for all the provinces in Canada and the territories, with the exception of Quebec, the common law is basically the same. So that defines most remedies available in Canadian employment circumstance. And the fundamental term that's been applied into every employment relationship is the employer has an obligation to give reasonable notice of termination. And that will vary depending upon many factors, but the most prominent of those factors are the length of the relationship, responsibilities, whether the employee has been induced to leave secure employment, and there's many others, but those are the fundamental ones. And that issue can give rise to an obligation on the part of the employer to give proper notice of termination. The employee will then have a claim for all the benefits of employment that he or she would have earned over that notice period. The highest notice period typically is about 2 years. There's some cases that have awarded a little more than that, 3 or 4 months more than that, but generally 2 years is considered the highest sum. So that forms the general basis of a claim that's called a claim for wrongful dismissal. The other important issue in all jurisdictions across Canada is that each province or territory has a minimum standard that has to be met on termination of employment. Ontario is the most generous. We'll discuss details later, but those are called the statutory entitlements on termination of employment. There is a further issue which deals with workplace human rights, and that's a remedy determined by statute in each jurisdiction. By and large, most of the human rights statutes are quite similar, although there are some differences occasionally, but generally the concept is that there are certain protected values in society by statute, and a violation of a statutory provision in an employment relationship can give rise to a claim for human rights violations. And again, those remedies are generally similar for each jurisdiction, with the exception of Ontario, which we'll discuss momentarily. So those remedies basically constitute the fundamental issues in an employment relationship that can lead to compensation being paid to the employee. There are many issues that have to be considered with respect to the common law claim. It's not quite as simple as I've made out so far, but that's basically the fundamental introduction. We can deal with issues as they develop in more complexity, but those are the fundamental terms that give rise to a claim for generally what is called wrongful dismissal, which just means termination without just cause, entitling the employee to a claim for lost compensation over the notice period. The human rights remedy is much different. It's completely different in concept, and we'll discuss that again momentarily. So that's the fundamental introduction.